adına webinarımıza katılım sağladığınız için teşekkür ediyorum. Hoş geldiniz diyorum. 2021 yılı başında faaliyetlerine başlayan Finansal ve Operasyonel Yapılandırma Profesyonelleri Derneği FOYDER olarak 2021 yılı Mart ayında gerçekleştirdiğimiz ilk genel kurulumuz ve sonrasında üyelerimizle yaptığımız arama toplantılarımızda yeniden yapılandırmaya ilişkin olumsuz algı, kalıcı ve kapsamlı bir yeniden yapılandırma düzenlemesine olan ihtiyaç öne çıkan konularımız olmuştu. Bu hususlar tabii ki aynı zamanda kuruluş amaçlarımızda yansıttığından ülkemizde uygulanabilir, kalıcı, mümkünse özel bir kanun düzenlemesine yönelik öneriler oluşturma çalışmalarına öncelik verdik. Bu kapsamda üyelerimizle mevcut yapılandırma uygulamalarımızdaki aksayan tarafları ve nasıl daha iyi bir sürecin oluşturulabileceğini tartıştık. Bu süreçte 2019 yılında tabii AB otoritelerince ortaya konan kısaca yapılandırma direktifi olarak tanımlayabileceğimiz direktif ile özellikle 2020 yılında üye ülkelerce gerçekleştirilen hukuki düzenlemeler bizim için önemli bir rehber mahiyetindeydi. 2021 yılı sonlarına doğru Türk-Alman Üniversitemizin değerli hocalarıyla birlikte bir çalışma başlattık. Bu kapsamda da Almanya'da 2021 yılında müstakil bir kanun olarak yürürlüğe giren İşletmelerin Stabilizasyonu ve Yeniden Yapılandırılması Kanunu hakkında araştırma raporu düzenlendi. Bugün de zaten ekibimizde bugün Anıl hocamızı dinliyor olacağız bu konuda. Süreç esnasında TMA üyesi ülkelerdeki TMA üyeleriyle görüştük. TMA Birleşik Krallık'tan Annan olan, Almanya'dan Müller, TMA Hollanda'dan Michel, yine TMA Almanya'dan bugün de panelistlerimizden biri olan Georg ve EVA ile görüşerek ülkelerindeki yapılandırma uygulamaları hakkında bilgi almış olduk. Bugünkü programımızda Avrupa Birliği'nin 2019 yılında yayınlamış olduğu bahsettiğim direktif ve sonrasında özellikle 2020 yılında Avrupa Birliği ülkelerinde ortaya konan yeni yapılandırma çerçevesi kapsamında iki önemli ülke uygulamasını, Hollanda ve Almanya uygulamalarını dinleyeceğiz ve detaylı bir şekilde öğrenmiş olacağız. Beklentimiz bu. Bundan sonraki süreçte de tabii sadece Avrupa Birliği ülkeleri değil, farklı ülke uygulamalarını da araştırarak ülkemiz gerçekleriyle de tabii ki uyumlu bir şekilde olacak, kalıcı ve bir yeniden yapılandırma çerçevesinin oluşturulması için TMA Türkiye olarak elimizden gelen tüm gayreti gösteriyor olacağız. Öneriler oluşturacağız, paydaşlarımızla bunları paylaşıyor olacağız. Webinarımızla ilgili de kısaca bir bilgi vereyim. Ekranın sağ üst köşesinde 3 nokta da olabilir. Oraya dokunduğunuzda simultane çeviri imkanı sunan linki tıkladığınızda çeviri imkanını bulabilirsiniz. Yine aynı yerde bulunan soru cevap kısmı veya en üst kısmında da olabilir. Soru cevap kısmında da moderatörlerimize ve panelistlerimize sorularınızı iletebilirsiniz. TMA Türkiye ve Sayın Başkanımız Hasan Tengiz Bey adına tüm katılımcılarımıza teşekkür ediyorum. Ve sahneyi moderatörümüz KPMG Türkiye Yeniden Yapılandırma lideri ve aynı zamanda ortağı ve yine TMA Türkiye üyesi olan Orhan Turan ve panelistlerimize bırakıyorum. Keyifli ve bilgilendirici bir panel diliyorum. Çok teşekkür ediyorum. Buyurun Orhan Bey.
Çok teşekkürler Önder Bey. Herkese merhaba. Güzel bir gün diliyorum herkese öncelikle. Önder Bey'in bahsettiği gibi bugünkü seminerimizde 3 değerli konuğumuz var. Bu konuklarımızdan ilki Sayın Mr. Georg Bernsau. I hope that I pronounce your name well, especially the surname. So, Georg global bir hukuk firması olan ve özellikle uzmanlık alanları arasında da icra, iflas ve yapılandırma hukuku işlerinin de yapıldığı global bir firma olan K&L Gates firmasının Frankfurt ofisinde bir partner. Çok uzun süredir yapılandırma ve icra işleri içerisinde yer alıyor. Aynı zamanda TMA Almanya'nın da önemli üyelerinden ve yöneticilerinden birisi. Bugün onunla birlikte aslında Almanya'daki icra iflas hukuku, bu Avrupa Birliği Direktif'ine uyumla ilgili yapılmış olan son düzenlemeler çerçevesinde biraz Almanya'daki sistem üzerine onunla tartışacağız. Yine bir değerli konuğumuz Hollanda'dan yine bir avukat dostum, meslektaşımız. O da yine aynı şekilde bir hukuk firması olan, ya Hollanda'da oldukça etkin olan Windler Grant Leeuwenburg firmasına çalışan Michael Bindels bizde olacak. Mikael de uzunca bir süredir yine yapılandırmalar ve icra iflas konularıyla ilgili, likidasyon konularıyla ilgili çalışıyor. Bu konuda da oldukça deneyimli bir avukat kendisi. Onunla da Hollanda'daki sistem, özellikle Hollanda'daki en son uygulamaya geçirilen Dutch Scheme olarak tarif edilen ve yapılandırma düzenlemesiyle ilgili yine önemli konular tartışacağız. Üçüncü katılımcımız, panelistimiz ise Türk-Alman Üniversitesi'nden bir öğretim üyesi Doktor Anıl Köroğlu. O da yine zaten hem Türkiye'deki konkordato rejimi hem de mevcut Türkiye'deki yapılandırma mevzuatı ile ilgili çalışmalar yürütmekle birlikte aynı zamanda özellikle Alman hukuku, Almanya'daki icra iflas hukukuyla Türkiye arasındaki ilişki, Türkiye'deki mevzuat arasındaki ilişkileri bizimle tartışacak ve diğer iki panelistimizin aktardığı bilgilerle Türkiye'deki mevzuat açısından neleri taşıyabileceğimizi bizlerle paylaşacak görüşlerini. Bildiğiniz gibi webinarımız çift dilli ve dileyen katılımcılar tercüme alanından İngilizceden Türkçe'ye ya da Türkçeden İngilizce'ye dinleyebilirler. Eğer herkes için de uygunsa ben özellikle Hollanda ve Almanya'dan katılan iki dostumuza İngilizce sorular yönelteceğim ve onlar o şekilde cevap verecekler. Anıl Bey'le yine Türkçe konuşmaya devam edeceğiz. Thank you very much, gentlemen, and for your patience, please. And we had kind of introduction. I made a very short introduction for you guys, but of course, whenever you take the floor, if you want to elaborate your past experience, it's up to you. So, Georg, I will start with the German insolvency law on insolvency regime. I know that Germany has a long-lasting and a very deep insolvency regime, and it has different phases starting from out-of-court restructurings to the formal restructurings and insolvency and liquidation. Would you please elaborate us about the German system, how it works, and particularly what has been recently added into the regulatory base? Thank you.
Thank you very much, Orhan, for your nice words, which I didn't understand in everything, but a bit was understandable. Yes, thank you very much for this question. I mean, I can talk about this for more than 1 hour, and I try to make it a little bit shorter. We became in 1999 a new insolvency regime. The law before was from 1872, so far as I can recall it, and it was quite new, and it has took over part of the American system, like the insolvency plan, so to enable a company to get restructured and to live after the insolvency proceedings. It was amended in 2012 through the improvement of the self-administration process. So most of the bigger cases in Germany at the moment, when they have to start with an insolvency proceedings, they start with the self-administration process, and we have two different things there to look about. One is what we call Schutzschirmverfahren, protective shield proceedings, that gives the management a broad possibility to restructure the company under the supervision of an administrator, but only in the background. We have the normal self-administration process, which means that there's still the management who can can do the restructuring for the company under the supervision of an administrator and by the court. And we have the regular proceedings, which normally they are only for smaller entities, and they not in 100%, but more than 90% will end into a liquidation of the company. And what is quite new, and that is something what will be adopted in any EU jurisdiction, it's coming from the EU directive from 2017, 2018. And this new law, which is called StaRUG, it's an acronym from Stabilisierung and Restructuring of a Company, was adopted in the beginning of 2021. So it's a little bit more than 1 year old. And this is not part of the insolvency regime. It's a different law. And it means that a company can be restructured on the liability side with a very, I would say, not that deep proceeding as an insolvency proceeding. You can collect certain creditors. I think we will talk about that a little bit more later. You can collect certain creditors, and you can restructure in that area the company. There's not an administrator needed. In some cases, we have what we call maybe a monitor, which is only supervising the process to the court. And it's not published in the it's not published, so it means that not all creditors or customers will be aware that this company is going through an insolvency process. Unfortunately, and then I'm at the end of the answer, only 20. So I know it's very precise because I read a couple of days ago the summary of the StaRUG proceedings in 2021. So unfortunately, only 22 entities went through this new law. In the first quarter of this year, it must be 20 at least. So the same number in 3 months as it was for 12 months in 2021, I'm quite sure. There will be a lot of more companies which came because of COVID, because of the lockdowns, and the Ukrainian crisis will come under pressure and will decide to go through this StaRUG proceeding. So that's quite new, and that is something what we think we will discuss it a little bit more in detail later. And it gives the company very good possibility to get restructured without the disadvantages of insolvency proceedings.
Thank you very much, Georg. As you said, we will go into a bit of details, and I have some questions for you for the German regime. But now I will turn to Michael, and I will start with the same question, actually, Michael. And I know that also the Holland also implemented some new addition to the insolvency regime in the Netherlands. And also, please, would you please a bit elaborate the Dutch regime and what has been added recently?
Yeah, sure. Thank you, Oran. Well, we have quite an old bankruptcy act. I think it dates from 1892. And originally for companies, it included 2 insolvency proceedings. One was the bankruptcy proceedings, which was actually aimed at liquidating the company. And the other one is the suspension of payments proceedings, which was originally intended to be the proceedings in which companies could be restructured. It provides for a mechanism where a scheme can be proposed and can be voted on by creditors. But the experiences in the Dutch restructuring market have been that the process itself is flawed because there are certain limitations as to what you can do in suspension of payments. For example, you cannot include secured creditors. So creditors who have security rights, such as a pledge or a mortgage, cannot be forced in the suspension of payments proceedings, nor can preferred creditors, such as the tax authorities or shareholders. And also the market perceives, maybe because the market actually perceives the suspension of payments proceedings as being more or less flawed, 9 out of 10 times, probably even more, a suspension of payments is simply sort of the first step towards a bankruptcy. So it is not seen as a viable restructuring tool. So it's a bit of a self-fulfilling prophecy it has become. So over the past years and maybe even past decade, there has been a lot of discussion and a lot of sort of requests from the restructuring community in the Netherlands to come up with a more efficient restructuring tool in the Netherlands, which has been implemented on the 1st of January of 2021. So as in Germany, we have a bit over a year of experience with it now. It is the Dutch scheme, and it has been based actually on the English scheme of arrangement and the Chapter 11 proceedings in the US. So it combines sort of aspects and tools which you know from these proceedings and what actually the Dutch scheme does. It foresees for a way to actually to distribute the value of a company. So it is actually aimed to restructure the debt or the equity of a company which is in financial difficulties, but in itself, business-wise, is still a viable company. So it allows you to propose a scheme to creditors, and you don't have to include all creditors. You can include shareholders if you like, so it's quite flexible in that respect, which allows you through the scheme actually to restructure your financial position and to make sure that your financial arrangements fit in with the business itself once more. So technically it has been implemented within the Bankruptcy Act, but it is to a great extent it is a consensual procedure. It's an out of court proceeding, so it is not a formal insolvency proceedings. You don't commence the Dutch scheme with a request to the court. So it is something which is to be arranged between parties. You can request, you can make certain requests to the court, for example, to the appointment of a restructuring expert who will then help the company, or at least actually on behalf of the company, propose the scheme, but that is not required. So it can be quite a flexible and quick process in terms of procedure which you need to go through, in terms of which creditors, shareholders you want to include, but also in terms of what you want to offer. You don't have to offer full cash payment. You can offer a debt to equity swap. There's a lot of freedom there as well. And I think, as Georg said, I think we had a bit more cases. Not all cases, not all rulings of the courts are published. But I think we had a bit over. So what we can see from the rulings which have been published, we can see that there have been, I think, over 40 last year, which sort of for the Dutch economic span is I think relatively more than in Germany. Then I would think, Georg.
Yep.
And sort of considering what we probably have not seen, because not all of the rulings have been published, it probably has been 60, which I think is perceived to be quite good for a new piece of legislation, for a completely new system in our jurisdiction. And what we actually see is that it is working quite well. The arrangement, the law it has high requirements because it is a very flexible and also quite intrusive what you can actually do in terms of amending the rights of creditors and shareholders. So there is a lot of paperwork to go through the procedure, but what we actually see is that it is being used by smaller companies as well for relatively simple restructurings, and we have also seen some bigger and more complex cases. I think we'll be speaking about that as well. So I mean, looking back at the first year, a bit over a year, I think people are quite positive of the experiences so far, and we hope that will be helping us through the crisis we all believe is near at hand.
Thank you very much, Mikael. We will go into the details, of course. And now I will turn to Anıl Bey. Anıl Bey, biraz da aslında Türkiye'de de tabii yapılandırma rejimi her ne kadar İcra İflas Kanunumuz oldukça eski, Cumhuriyet'in ilk yıllarından kalma da olsa ve sonra da önemli değişiklikler olsa da aslında yapılandırma Türkiye'de finansal sektörün ya da reel sektörün önüne dönem dönem daha fazla çıkıyor. Daha sonra da dönem dönem de unutuluyor. Çok farklı yasal uygulamalar gördük. İflas ertelemesini yaşadık. Sonra konkordatoyu gördük. Konkordatonun tekrar revize edilmesini gördük. Siz bir bütün olarak baktığınızda hem tabii uzmanlık alanınız olan Alman hukuk sistemiyle ilgili de olabilir ama ben genel olarak Türkiye'deki İcra İflas Kanunu ile ilgili neler görüyorsunuz? Şirketlerin yapılandırılmasında ya da şirketlerin borç acizi durumu ile ilgili ne kadar efektif buluyorsunuz? Bir genel değerlendirmeyle başlarsak sonrasında size de detay sorularım olacak.
Teşekkür ederim Orhan Bey. Dediğiniz gibi genellikle yeniden yapılandırmaya ilişkin temel mevzuat aslında İcra İflas Kanunu gibi görünmekte. Fakat şu anda en çok gündemde olan konkordato esasen bir yeniden yapılandırma kurumu değil. Çünkü önemli ölçüde ayrışmakta. Türk mevzuatına genel olarak baktığımızda Önder Bey'in de başlangıçta ifade ettiği gibi yeniden yapılandırmaya ilişkin mevzuatların dağınık olduğunu ve tek bir yerde toplanmadığını görüyoruz. Yine İcra İflas Kanunu'nda bundan yaklaşık 10 yıl kadar önce aynı anda iflasın ertelenmesi, konkordato, uzlaştırma yoluyla yeniden yapılandırma kurumları aynı anda yürürlükteydi. Tabii böyle olduğu zaman şöyle bir sıkıntı da ortaya çıkmakta. Birden fazla birbirine benzer düzenlemeler olduğunda bu düzenlemelerde borçlu, yani bu yola başvurabilecek olan kişi kendisi bakımından en uygun yol neyse, kendisine en fazla koruma hangi kurum veriyorsa borçlunun bu yolu tercih ettiğini görmüştük. Örnekse iflasın ertelenmesi kurumu yürürlükteyken, kaldırılmamışken borçluların ağırlıklı olarak iflasın ertelenmesi kurumunu tercih ettiklerini gördük. Bunun da tabii temel nedeni mahkemeye başvuruyla birlikte mahkemenin, ticaret mahkemesinin, iflas ertelemesi başvurusu alan ticaret mahkemesinin hemen çok da detaya girmeden bir yıllık bir borçluya süre verdiğini ve bu süre zarfında borçluya karşı yapılabilecek tüm takiplerin yasaklandığını veya mevcut yapılmış olan takiplerinde durdurulduğunu görmekteydik. Hatta uygulama o kadar artık bir noktaya geldi ki neredeyse her başvuran borçluya gerçekten iflas ertelenmesine ilişkin şartlar mevcut mu, borca batıklık veya bu tehlikesi var mı noktasında çok da detaylı incelemeden bu sürenin verildiğini görmekteydik daha doğrusu. Tabi bu böyle olduğu zaman alacakların alacaklılarına geç kavuşması ve hatta borçlu alacaklar arasındaki dengenin önemli ölçüde borçlu lehine bozulduğunu görmekteydik. Tabii iflasın ertelenmesi kurumu varken yine kanunumuzda uzlaştırma yoluyla yeniden yapılandırma metodu da, kurumu da mevcuttu. Ki aslında bu kurum bugün de konuşulacak olan Alman Yeniden Yapılandırma Kanunu'na en çok benzeyen kurum, İcra İflas Kanunu içindeki uzlaştırma yoluyla yeniden yapılandırma kurumu. Fakat borçlular dediğim gibi bu yola başvurmaktan çekinmekteydi. Çünkü iflasın ertelenmesinde olduğunun aksine borçluyu belli bir aşamaya kadar icra takiplerinden koruma bakımından uzlaştırma yoluyla yeniden yapılandırma kurumu bu bakımdan borçluya bir hareket alanı vermiyordu. Gerçekten borçlu yeniden yapılandırmada seçeceği alacaklar bakımından böyle bir proje yapalım, böyle bir plan yapalım dediğinde korunmasız kalıyordu. Çünkü piyasada ya da iş çevrelerinde borçlunun yeniden yapılandırma arayışı içinde olduğu, duyulduğu takdirde alacaklılar pek tabii ki kendilerini düşünerek hemen borçluya karşı icra takiplerine girişiyorlardı. Dolayısıyla böyle bir icra takibi olduğu zaman da borçlunun önemli malları haczedilebiliyor ve aslında başlangıçta yapılandırma projesinin hüsranla sonuçlanması ortaya çıkıyordu. Tabii bu önemli bir eksiklik. Hala da devam ediyor aslında uzlaştırma yoluyla yeniden yapılandırmaya neden bugün başvurulmuyor? Sebebi bu. Şimdi de konkordato var. Dediğiniz gibi önceleri iflas ertelenmesinin yürürlükte olduğu dönemde bu konkordato var mıydı? Şüphesiz vardı. Fakat burada da borçluya icra takipleri yasaklanması, o koruma, o şemsiye sadece 5 ayla sınırlı olarak uygulanıyordu. Ve borçlu da bu yolu tercih etmiyordu. Doğrudan iflas ertelenmesine başvuruyordu. Kanun tabii bu kötüye uygulamaları kanun koyucu tespit edip iflasın ertelenmesine ilişkin hükümleri kaldırdı. Ve konkordatoyu biraz daha özellikle söylediğim o takip yasağı bakımından mühlet süresinin uzatılması hususunda neredeyse 2 yıla kadar, 1,5 yıla kadar uzatılabilmesi mümkün şu anda hukukumuzda takip yasağı bakımından. Konkordatoyu bu şekilde getirdi ama tabii konkordato dediğim gibi başlangıçta söyledim bir yeniden yapılandırma değil, bir daha ziyade borçlunun iflasının önlenmesine, borçlunun iflas etmesine iflasını önleme bakımından getirilen bir yol ya da borçların tasfiyesiyle ilişkili bir yol. Yoksa yeniden yapılandırmada olduğu gibi şirketin güçlendirilmesi, işte toplumda iktisadi hayata kazandırılması, bir daha işte ödeme güçlüğüne düşmemesi için getirilen bir yol değil. O bakımdan birbirinden farklı iki kurum, şüphesiz detaylarını da hem Alman hukukunda hem Türk hukukunda göreceğiz ama İcra İflas Kanunu dışında çeşitli kanunlarda da özellikle küçük ve orta büyüklükteki işletmelerin yapılandırılması gibi farklı kanunlar ve yönetmelikler de var. Ben bitirirken şunu söylüyorum, bu başlangıçta hemen şunu söylemek isterim. Genellikle tek bir kanun olarak bunların bir araya getirilmesi daha isabetli olacak. Alman hukukuna baktığımızda da dediğim gibi detayları tekrar konuşacağız. Teşekkür ederim.
Çok teşekkürler Anıl Bey. Katılımcılara bir kez daha panelistlerimize sorularını Q&A bölümünden iletebileceklerini bir kere daha söylemek isterim. Sizlerin soruları olursa onları yöneltmekten ben de keyif alacağım. Georg, when I first read the EU's directive on the restructuring through the EU, all the EU countries, few words were a bit interesting to me when I first read. One of them was the importance of the early preventive restructurings, and then the second chance option, which was also very interesting to me. And also the viability of the company was also key to the EU directive together with the other components. How effective do you think the German insolvency regime, I mean as a whole, on these matters? Because EU directive is asking some of the issues to be implemented in EU-wide, but also in some other points gives the member states a bit of elasticity. So how do you think, especially on the early preventive restructurings, viability, second chance, those are kind of the terms or the approach that's trying to protect entrepreneurship and also the businesses which are viable, whatever the debt and their balance sheet is. So how effective do you think the German system with this regards?
Well, once again, you cannot answer it with one question. One point for the EU directive. The EU directive is done for 27 member states. And the status of the insolvency regimes are very different. So if you look maybe into Poland and you compare it with France, there are very big differences, and they want to get one, not the same, but similar restructuring regimes. So in every jurisdiction, the legislator looked into this EU directive and compared it what has to be done to fulfill this directive. And as Michael said, for Netherlands, we had, and mentioned it, there are a lot of new laws which had been done since 1999 and especially in 2012 when the self-administration was implemented. So there were a lot of more flexibility for companies to get restructured. It means, so in the beginning, this old law was very clear for creditors and to secure creditors and especially collaterals. Now there's a shift starting in Germany. So you can see it in every insolvency regime in the world. So there's a shift more away from the creditors to save entrepreneurs or to save the company for the sake of that employees will be employed, that this company has the chance to survive the insolvency process. So that is a development over the last 20 years. And in the EU directive, you can read that this should be increased. And this is what the German legislator took out of the directive, compared it with the existing laws, and put a new one, which is called this StaRUG. I have to say that this discussion before the EU directive was a very long one in Germany. So a lot of people like me said we need something which is not an insolvency process, because that is a surgery which maybe for a patient which is not necessary. If you have a stable business but you have problems with banks or you have problems with shareholders, then it's not necessary to step into this insolvency process. So we always ask to have something which is not that bloody, as I can say this, as an insolvency proceeding. And I think now we have just the experience of 15 months, but I think there are two things I have to state about the German law. One is it is more flexible, much more flexible as it was 5 years ago, 10 years or 15 years ago. But however, it's still very formal. So the German legislator always looks that you get a codified law which is very stable, and it should be the result should be foreseen for creditors and for debtors. And because of that, the process, and when I heard from Michael that there are 40 proceedings in the Netherlands, which are a little bit smaller than Germany, and we have only 20 in Germany, I see that is more flexible, I suppose. But on the other side, it's working. And what my experience, and I heard it from a lot of colleagues, is when you start a restructuring process and you mention the word StaRUG, a lot of creditors says, okay, it's not necessary that we step into this process. We will negotiate it outside, and this is an improvement for the out-of-court restructuring. So at the end, to answer your question with one sentence, it means, yes, it's more flexible. The German system has improved. However, it's very formal, and it needs a lot of advisors to get this work done.
Well, I have a few other questions which comes with your answer to me, but I will take my notes. And for the next turn, I will try to ask those to you. So, Michael, as I know from the outside, Netherlands or Dutch, Holland is more for out-of-court restructuring jurisdiction. And both lenders and the companies tend to have negotiation among themselves, and this is the way that we see from the, let's say, outside of the country. So, but with these new regulations and Dutch scheme, of course, is also bringing new elasticities to the corporates and the creditors. But I would like to discuss with you about the effectiveness of the court in the process. When I say court, I also would like to include the restructuring expert, which has been assigned by the court. In some, how you see the effectiveness of court involvement into the regime, where the corporates and the creditors traditionally tend to do it in out-of-court restructuring.
Yeah, well, I think as you say, Oran, we have a lot of the restructurings in the Netherlands tend to be on a consensual basis. What the Dutch scheme adds to that, and actually that is explicitly stipulated in the notes to the legislation, that the Dutch scheme, if not for anything else, it actually serves to reinforce this consensual restructuring practice. And what it actually does, it gives you the opportunity. We now have a means to force a restructuring on this one dissenting creditor or this one shareholder with a holdout position, which we in the past never had, because you had to do a deal. You had to do a deal with everyone. Otherwise, there was no deal, so no restructuring. And now, actually, sort of within the framework of the Dutch scheme, you can actually you can still have your negotiations, and at some point you can actually start preparing for the Dutch scheme, maybe threaten with the Dutch scheme, and people at the negotiating table will actually know that you will have means to force them into a deal. So we hope, and we see that in some of the cases, that it will actually sort of even strengthen the practice we have with consensual restructures, because it does give you the sort of the opportunity to take the deal to court, to take the deal into a vote actually for creditors, and have the creditors approve the deal, and then take it to court and have it approved by the court and be enforceable against all parties. So I think that is sort of from our practice that is a big added value. It is, I think, as Georg said, what we see now, it is quite flexible, and I think one of the very flexible aspects is the involvement of the court, which is formally, so technically it is only required for the approval of the scheme. So you can have your negotiations, you can have your preparations, you present the scheme to the creditors or the shareholders who will be involved, so whose rights will be amended through the scheme, whose rights are impacted by the scheme. They will have a vote. We have all these rules about voting, and if within that framework the scheme is accepted with a sufficient majority within one or more of the classes, then you present it to the court for the court's approval, and the court will review the scheme and review the process to come to the scheme from its office, so by itself, but also some of the dissenting creditors can actually raise objections. They are quite limited, but that is the only formality that is the only required involvement of the court. What you can do, however, is you can sort of in your process, so in the preparations, you can make various applications to the court. For example, you can ask for a moratorium. You can ask for the appointment of a restructuring expert. You can ask for a sort of a ruling in advance on certain aspects of the scheme you are preparing. So if you are not sure about the basis of the valuation, or if you're not sure about the way you are dealing with creditors by dividing them into classes, you would actually go to the court and say, well, this is my plan. This is why I think that this should work. What are your views? And the court may invite some of the interested parties, some of the creditors, to share their views as well. And you can get an advance ruling on what you are actually planning to do. So that gives you a lot of deal certainty. You can actually prepare the scheme, go to court to have some of the aspects already sort of pre-approved, so that you are sure that once you present the scheme with those aspects, that it will, if accepted by the creditors, it will also be approved by the court, or at least it will not be disapproved on those on the basis of those aspects. So it is quite flexible, and we see what we see in particular, that a lot of the applications to court are for moratorium. So for a stay of all sorts of enforcement actions by creditors or security rights holders. And that is what is quite often used, and we also see some of these requests sort of for a ruling on some aspects of the scheme to be presented. So it is being used quite well. But the basic principle is that is the flexibility of the proceeding. So it is not required to go to court. You only need to go to court for the approval way at the end of your system. Then for your question about the restructuring expert, again, the system is flexible, so you're not required to have a restructuring expert appointed. Actually, the debtor itself can prepare and present the scheme, do all the negotiations and the preparations. You would only need a lawyer to file the formal approval. You would normally expect that lawyers would be earlier involved in terms of advising on the process and assisting with the negotiations and the preparations. But the debtor, so the board of directors of the company, can do all of that by themselves if they want to. The debtor can request the court to appoint a restructuring expert if it believes that it needs certain assistance, or if it wants to have an objective third party actually prepare the scheme, because it has there are some tensions with the creditors, and there are some doubts with the creditor population whether the directors are actually looking at this objectively. But also that's also good to note. Also, creditors and employee representatives and shareholders can actually request support for a restructuring expert if they feel that the company or the debtor is not taking adequate action to come to a restructuring, or that it is not preparing a right scheme. Creditors can actually turn to the courts and ask for a restructuring expert to be appointed.
Thank you very much, Victor. Anıl Bey, ben başka ülkelerdeki mevzuata ilişkin böyle bir hızlı okuma var. Tabii bir hukukçu değil, bir finansal danışman, finansal perspektiften bakan birisi olarak hızlıca mevzuatı taradığında aslında yapılandırma rejimlerinin her ülkede belli bir felsefi altyapısının olduğu gibi bir sonuca vardım. Yani neyi kastediyorum? Her ülkedeki rejim aslında belli bir önceliği esas alıp onu korumaya çalışıyor. Bunun somut örneklerine bakacak olursak, mesela İtalya'da SME'ler, aile şirketleri çok önemlidir ve bunun çok önemli bir parçası olduğunu görüyorsunuz İtalya'daki rejimde. Ya da Fransa'daki işte safeguard rejimde istihdamın yine çok önemli olduğunu görüyorsunuz. Amerika Chapter 11'da işletmenin korunması ya da İngiltere'de finansal hub olma durumunun korunması gibi şeyler görüyorsunuz. Ben Türkiye'deki sisteme baktığınız zaman bütün bu, özellikle 2018'de hayatımıza giren finansal yapılandırma çerçeve kanunu ve ona bağlı finansal yapılandırma çerçeve anlaşması dahil olmak üzere, ki bu oldukça da yoğun bir şekilde kullanıldığını da gördük son 3-4 yıl içerisinde. Burada bir felsefi altyapı siz görüyor musunuz? Türkiye'deki rejim aslında neyi korumayı hedefliyor? Ya da böyle bir şeye gereksinim duyuyor musunuz? Nasıl değerlendiriyorsunuz Türkiye'deki rejimin öncelikleri, insolvency rejiminin öncelikleri bağlamında ya da yapılandırma mevzuatının?
Teşekkür ederim Orhan Bey. Girişte de söylediğim gibi yani bir kere bizde şimdi Alman hukuku ve işte Hollanda hukukundan farklı olarak genel yaklaşım bir kere farklı. Bizde alacaklıların alacağının ödenmesinin ağırlık kazandığı sistem oluştururken bunu görmekteyiz. Şimdi en yakın tarihli konkordato örneği. Burada da hep alacaklılar ön plana çıkarılmış. Halbuki Alman hukukuna baktığımızda StaRUG düzenlemesine baktığımızda oradan okuduklarım, her benzo tabii ki düzeltebilir eğer bir yanlışım olursa, borçlunun tüm sürece hakim olduğunu görmekteyiz. Yani süreci borçlu başlatıyor, işte toplantıları vesaire o yönetiyor. Çok sınırlı hallerde mahkemenin müdahalesi öne çıkıyor. Fakat Türk hukukuna baktığımızda borçlunun böyle bir serbestisi yok. Bahsetmiş olduğumuz 2018 yılındaki düzenlemelerde de genellikle alacaklıların ön plana çıktığını, alacağın ödenmesi ve tasfiye usulünün öne çıktığını görmekteyiz. Tabii ki bu böyle yollar olmalı. Şüphesiz konkordatoya da bazı yerlerde ihtiyaç var borçların tasfiyesi açısından ama biz yapılandırma dediğimizde borçlunun daha önde olması, düzenlemelerle süreci yönetmesinin önem kazandığını görmekteyiz. Bu sorunuz vesilesiyle ben bir hususu dikkatinizi çekmek isterim. Konkordatoda özellikle her ne kadar yeniden yapılandırma olmasa da işlerin yine alacaklı tarafından alacaklıların daha hakim konuma getirilmesi bakımından bir örnek vermek istiyorum. Biz de İcra İflas Kanunumuzun 297. maddesi var İcra İflas Kanunu'nda. Konkordatoya başvuran borçlunun borçlu hakkında kesin mühlet kararı verilmesiyle birlikte nasıl bunun sonuçlarına ilişkin, bu mühlet içinde nelerin yapabileceği, nelerin yapamayacağına ilişkin bir madde var. Bu 297. maddenin ikinci fıkrası geçtiğimiz yaz değiştirildi. Özellikle şu hükme dikkatinizi çekmek isterim. İşte bu 297. maddenin ikinci fıkrası diyor ki, borçlu mahkemenin izni dışında mühlet kararından itibaren rehin tesis edemez, kefil olamaz, ivazsız tasarruflarda bulunamaz, taşınmazını işte önemli şeyleri devredemez gibi ve mahkeme bu işlemler hakkında karar vermeden önce komiserin görüşüyle alacaklılar kurulunun muvaffakatini almak zorundadır. Şimdi burada aslında konkordatoda da bir borçlunun bir özgürlük alanı vardı. Fakat bu maddeyle bir yaklaşımı ortaya koymak istiyorum. Burada alacaklar kurulu izin vermez ise borçlu konkordato mühleti içinde dahi önemli kararları vermekten yoksun. Burada alacaklar kurulu tabii ki uygulamada çok sayıda oluşmuyor alacaklar kurulu şartları zor ama mesela bizim MEAS kanunumuza İsviçre'ye baktığımızda mahkemenin bu yönde izni yeterli. Şimdi biz MEAS İsviçre'den aldık fakat Türkiye'yi uyarlarken 2018 yılında yapmadık ama bu son 2021 yılındaki değişiklikte hem mahkemenin böyle bir karar verebilmesi için, izin verebilmesi için mühlet içinde yapılan işlemlere alacaklar kurulunun bunun onaylamasını da şart koştuk. Şimdi alacaklar kurulu pek tabii ki alacaklıları temsil edilen o kurul, alacaklıların yer aldığı kurul kendi menfaatlerini öne çıkarabilir. Alacakların menfaatleri ve borçlunun menfaati arasında bir çatışma olacaktır. Şüphesiz burada belki konkordatoda istenilen verim elde edilemeyecektir. Tabii özellikle konkordatoyu söyledim çünkü yaklaşım olarak dediğim gibi geçmiş düzenlemeler, şimdiki düzenlemeler, işte bankacılık kanunu ilgili madde çerçevesi hazırlanan yeniden yapılandırmaya benzeyen yönetmelikte de borçlunun süreçte biraz daha söz hakkının kısıtlandığını görmekteyiz. Bu da tespit edebildiğim kadarıyla örneğin Alman hukukunda ayrıştığımız belki de temel nokta. Son olarak şunu da söyleyip sözlerime son vermek istiyorum. Bizde biraz da mahkemelerin uzmanlığı olmadığı için bu alanlarda maalesef işte örneğin konkordatoda süreci aslında ağırlıklı olarak konkordato komiserinin yürüttüğünü, işte zamanında iflas ertelemede kayyımın yürüttüğünü görüyoruz. Şimdi biz bugün bir şeyler önerdiğimizde, örneğin yeniden yapılandırmayı önerdiğimizde, yeniden yapılandırmada da şimdi bizim kanunumuzda da var, proje denetçisi atanıyor mahkeme tarafından ara dönemde. Şimdi şüphesiz uzmanlık belli bir seviyede olmadan bu şekilde bir yaklaşım da süreci aslında alacaklılar ve işte mahkemenin atayacağı komiser ya da işte denetçi gibi kişiler arasında olmasına neden olacak diye düşünüyorum. Bu şekilde yanıtlayabilirim sorunuzu.
Çok teşekkürler Anıl Bey. Georg, I have a few questions from the audiences and I think it is also time to direct those to you. Of course, 15 months is a very short term to analyze a new regime. And 2 years ago, there was a seminar, maybe not 2.5 years ago, there was a seminar in Istanbul where a former governor of Central Bank of India was also attended. And I remember one sentence that he shared with the audience, and he said that after many amendments, then we announced that now we have the final version of the regime. And we had another 10 in the next few years. So this kind of regimes has to be alive and has to be subject to update on every level. And I think that could be one of the key things to develop best performing insolvency regime all over the world in every jurisdiction. So one of the audience is asking that for the time being, for the first 15 months, how do you see the main obstacles that StaRUG has encountered? And particularly, he has also one addition, and together with that, would you please also focus on the difference between the courts in StaRUG and courts in insolvency court? Thank you.
Okay, hopefully I can answer all the questions. Yes, alignment is always necessary for every new law. So the legislator in Germany said we will have an evaluation phase over 5 years. And after 5 years, we will look into whether certain amendments, alignments, or whatever are necessary. So the same appeared to this, what I called ESOC 8 years ago, 10 years ago now. And it was aligned after 5 years as well, together with this StaRUG. So alignment is always necessary. I don't think, like the Indian Prime Minister, that it will be totally different after 10 years, because StaRUG stands not alone. It has a lot of parts from the German Insolvency Code is transferred into this new law. So we can look a lot, or we can need the experience from the insolvency law. For instance, the cram down regulations and the insolvency plan, which is called in the StaRUG restructuring plan, are quite similar on a certain basis. So I think that is something which is not necessary within months, but for sure after 4 or 5 years it will be necessary. What are the clear disadvantages, or what are the necessary amendments? Yes, I can give you a little bit more insight what happened before this new law was adopted in 2021. We had a very long discussion in the second half of 2020 whether it will be possible, and that is what the Dutch scheme has, so far as I'm informed. We are not allowed, according to StaRUG, to terminate long-lasting contracts, like landlord contracts, lease contracts over real estate, or anything like that. If that is necessary, if you want to terminate a long-lasting renting contract, then you have to step into insolvency proceeding. We said from our part, it would be quite better to have this possibility within a StaRUG proceeding, because this is a very small change, and it's not necessary to put the whole company into insolvency proceeding. So that's the disadvantage number one. It was long discussed, and unfortunately, the legislator didn't take it over. So this is one thing which is missing. The second is there was what we called the English word fiduciary of duties. When the management is aware that this company must be restructured, and if you do not restructure it, it will become insolvent, it would be necessary that these duties of the managing directors must be shifted from the shareholders to the creditors. So at this, it would mean in that stadium that a lot of managing directors have to think whether they step into a StaRUG proceeding to avoid to go into an insolvency proceedings. Unfortunately, the same appeared here. The legislator did not take this over, and it's still missing. I think, and this is one of the, from all the TMA German chapter, we asked the legislator to make this or these amendments very soon because they are necessary for it. And the third question was regarding the insolvency court, whether we have restructuring courts and insolvency courts. Well, to be honest, we have insolvency courts, that's for sure. That's are the Amtsgerichte, that's are the lowest court. And the insolvency courts are working as restructuring courts as well. So if you are going with a StaRUG proceeding to a court, if you need this approval, like Michael said, which is necessary in Germany as well, if you want to have the approval from the court, then you go to the restructuring court, but this is the same insolvency court. So it's at the court, they have the same proceedings. This has the disadvantage maybe that you are going to an insolvency judge and he sometimes needs a little bit time that he distinguish between a StaRUG proceeding and an insolvency proceeding. Sometimes he said insolvency, but he means structuring or out of court restructuring. But at the end, it means that you have the experience of this insolvency judges, which are mostly, not all of them, unfortunately, very experienced with this kind of proceedings. And because they handled the insolvency plans, they are very good to handle these restructuring plans. They know how the voting will take place. They are very experienced. And I think it's the right way to have it in the insolvency courts. Although the discussion before was, no, we need the normal civil courts. We don't want to go to the insolvency courts. But I think the benefit to go to an experienced court is much better than to ask someone who is for the first time working with it. Thanks. I don't know whether I have answered all your questions. Hopefully I have.
Well, I'm sure that you may go into more detail, but for the time being, I think you well covered my question. So if our attendees would have other questions, of course, I will direct it to you. Michael, you said that in Netherlands, the number of the proceedings or number of restructuring through the new regime is, let's say, seems to be much higher than Germany. And given the size of both countries, it is fair to say that it is much more used, I would say. How do you observe all stakeholders in the corporate debt restructurings with the new regime? How supportive the lenders and the corporates and all other stakeholders into the regime? Do you think that everyone is supportive, or is there any specific objection coming from certain stakeholders? And together with that, I will also ask one of the questions coming from the attendees to you. Is there any incentives to the corporates or to the lenders in this process under the Dutch scheme, such as the tax benefit or kind of cost of credit for the lenders? Is there any certain incentives in the regime?
Well, to start with your first question, I think, the wish for a new restructuring tool was quite broad in the Dutch restructuring market. So for all professionals and also for banks, because sort of under the old regimes, I think it was clear to everyone that actually value was being lost because some viable companies were just simply not able of being restructured, or the restructurings, that is also what we see, were actually being moved abroad. So we're brought to England for a scheme of arrangements, or maybe even to the US for a Chapter 11 proceedings. And obviously now that the regulation is there, I think generally people feel that it works. People feel that the courts are actually doing a good job in reviewing all the requests. They are being quite meticulous on some of the formal aspects, but they're being flexible where flexibility is required and desirable. I know, for example, that the banks, there have been some in the legislative process, there have been some amendments quite late on in the process, which are somewhat detrimental to the position of banks, secured creditors. So I know there is a bit of criticism around that. And one of the cases which we have seen, one of the bigger cases which we have seen, is actually where a group of lenders was actually forced to continue its financing. So the senior creditors voted against the scheme, but because one of the preferred creditors, the Dutch tax authority, actually voted in favor of the scheme, there was a cram down. And in respect of the senior creditors, it entailed that the financing arrangement, actually the agreement, was amended on certain points, and that was actually forced on those financing parties by the court, actually by the court approving the scheme against their will. So that is something which is that the concept of that possibility is a bit frowned upon by financiers. And I think in your, what was your second question again, Warren?
Sorry, I was on mute. So the second question of is the new regime, Dutch scheme, is bringing any incentive to the stakeholders?
Yeah, well, no, there is no specific incentive, but obviously the big incentive is that you can actually reduce your debt. And as I said, actually all sorts of debts can be included. There's one exception, that is the debts which relate to an employment contract. You cannot reduce those. You cannot include those in a scheme. But so you can include your social. You can include your tax debt. All sorts of your wage debt, whatever. You can include all of that, and you can also, as Georg mentioned, there is a possibility of actually amending or terminating long-lasting contracts in the Dutch scheme. The way that works is that you, during your preparations for the scheme, you can actually enter into negotiations. You can make a proposal. That's a formal requirement. You need to make a proposal to your counterparty for an amendment of the agreement. So let's say the landlord of your building. You want to change the terms of the lease because the building is too big for you. You need lesser square meters, or the rent is too high. So you make a proposal, and if that proposal is rejected and you can't reach an agreement on that, you can actually include in your request for approval of the scheme, you can include a request for a permission to terminate the contract. And actually, with the approval of the scheme, the termination of the contract will be effective. And what the Dutch scheme then allows you to do is, so in the scheme, you can actually also reduce the claim for damages. So as an example, with the lease contract, if you have a 10-year lease and you want to terminate it after 2 years, you probably have to pay 8 years in fines to your landlord. And that is actually a claim which you can also include in the scheme. So you can not only terminate the contracts, but you can also sort of include and therewith reduce the claim for damages. So I think in terms of what are sort of the big benefits of the scheme, there are no particular upsides, but I think obviously the big upside, the big benefit of this whole process would be that you can sort of reduce your financial liabilities, which actually allows the company to continue trade with a lot more friendly leverage position, with a lot more financial obligations going forward.
Before going to the other attendees, Michael, I just like to ask a question coming from one of our attendees. Does the public debt, such as tax and social security debts, are they included into the scheme?
Yeah, they can be.
Okay, so I mean, maybe I may ask the same to Georg before asking my question to Anıl Bey. What about in Germany? Does the public debt or tax and security, social security payments are also included?
Yeah.
Okay. Thank you very much. Anıl Bey, bugün aslında tabii çok geniş kapsamlı iki regülasyon, iki mevzuat altyapısından bahsediyoruz iki ülkedeki, ama tabii her detaya bugün giremeyeceğiz ve katılımcılarımız açısından da çok fazla hukuki bir tartışmaya da götürmek de çok verimli olmayabilir. Ben ama yine bu noktadan size şöyle bir soruyla gelmek istiyorum. Bütün bu duyduklarımız sizin kendi gözlemleriniz ve Türkiye'de de biliyorsunuz yine bankalar ve şirketler aslında formal süreçlere, mahkeme gözetimi altındaki süreçler yerine aslında mahkeme dışında müzakere yöntemiyle yapılandırmalarda sonuç üretmeye eğilimliler. Zaten aslında bu finansal yapılandırma çerçeve anlaşmasının diğer rejimlerin önüne geçmesinin aslında en temel sebebi de bu. Ben sizin gözlemlerinizle bir hukukçu olarak ve özellikle Avrupa'daki sistemleri de yakından bilen bir hukukçu olarak sizce Türkiye'de şirketlerin sağlıklı hale getirilmesi ya da yapılandırılması yoluyla rehabilitasyonu bağlamında en acil ve en hızlı ya da en önemli gördüğünüz değişiklikler ve güncellemeler neler olmalıdır?
Evet, teşekkür ederim sorunuz için Orhan Bey. Tabii yine İcra İflas Kanunu'nda bizde dediğim gibi Alman StaRUG düzenlemesine en çok benzeyen temel mevzuatımız içinde yer alan uzlaştırma yoluyla yeniden yapılandırma İcra İflas Kanunu 309. maddesinde düzenlenen kurum. Dolayısıyla sorunuzu da belki bu çerçevede ele almak gerekir. Tabii buradaki ayrı bir kanun veya mevcut kanun içinde bu kanunun tadili düzeltilmesiyle bazı değişiklikler yapılabilir. Sorunuzu ilk etapta şöyle yanıtlayabilirim. Şimdi 309. madde kapsamında yani İcra İflas Kanunu'na göre yeniden yapılandırmaya kimler başvurabilir noktasında bir kere kanun çok ciddi bir sınırlama yapmış. Hemen o maddeyi de direkt okumak için tekrar bakayım. Evet, şu an bulamadım ama genel olarak sermaye şirketleriyle sınırlı bu. Her benzo tabii düzeltebilir bir yanlışım olursa ama StaRUG'da böyle bir sınırlama yok. İflasa tabi borçlular ki ağırlıklı olarak tacirler bu yola başvurabilir. Şimdi bizde daha başlangıçta İcra İflas Kanunu'na göre yeniden yapılandırmaya başvuracak olan sadece sermaye şirketleri. Bu bakımdan önemli bir eksiklik olduğunu düşünüyorum ben. Sadece sermaye şirketleriyle sınırlamanın çok da doğru olmadığını ve yeniden yapılandırmanın muhtevasına çok da uygun olmadığını düşünüyorum. Belki temel değişiklik bu çerçevede olabilir. Almanya'daki gibi buna iflasa tabi borçlularla genişletilebilir. Aksi takdirde burada kanunda böyle bir hüküm olduğu için belki borçlu istemeyerek de olsa belki konkordataya başvuracaktır ya da başka kurumları deneyecektir. Halbuki yeniden yapılandırma oldukça önemli bir kurum. Tabii her iflasa tabi borçlular başvuramayacaktır. Dolayısıyla bu Almanya'da da böyle düzenlenmiş. İşte bankalar ya da sigorta şirketleri bu yola başvuramayacaktır şüphesiz. Bunu da söylemek isterim. İkinci olarak Orhan Bey sorunuzla alakalı önemli bir değişiklik şu konuda yapılabilir. Şimdi bizde Alman hukukuna baktığımızda da bu erken uyarı sistemi diye tabir edilen bir sistem. Şimdi bu Türkiye'de var mı? Şüphesiz var ama Almanya'daki ya da işte Hollanda'daki gibi değil. Nedeni de şu, şimdi bizde dediğim gibi erken uyarı sistemi İcra İflas Kanunu yok ama Ticaret Kanunu'na getirilmiş bir düzenleme. Fakat burada özellikle şunu söylemek gerekir erken uyarı sistemiyle alakalı. İşte Türk Ticaret Kanunu yanılmıyorsam 379. maddesi olmalı. Bu büyük ölçekteki şirketler için belli bir riskin erken teşhisi gibi 378. madde riskin erken teşhisi için şirketlerin komite kurması ve kurulan bu komitenin yönetim kuruluna 2 ayda bir rapor vermesi gerektiğini ifade etmekte. Tabii bu sadece bazı şirketler için zorunlu Türk hukukunda ve daha genel bir tabirle daha genel söyleyecek olursam büyük ölçekli şirketler için bu yol öngörülmüş. Fakat küçük ve orta büyüklükteki bir şirket için de erken uyarı sistemi ki zaten erken uyarı sistemi sayesinde belki de yapılandırma ileride yapılacak, yapılandırma başarılı olacak. Dolayısıyla dünyadaki trendin de hakeza Alman hukukundaki trendin de burada bir ayrımın yapılmaması büyük ölçekli şirket olabilir. Fakat küçük ve orta büyüklük ölçekteki bir şirket de olabilir. Dolayısıyla burada ilk etapta erken uyarı sistemi bakımından bunun kapsamının daha da genişletilmesi gerekir. İkinci problem yine Türk hukukuyla alakalı erken uyarı sistemiyle ilgili. Burada riskin tespit edilmesi ve yönetim kuruluna haber verilmesi sonrasında kanunda yönetim kurulunun ne yapacağı hususu belirsiz. Bunu yaparsa bir sorumluluğu olur mu olmaz mı? Daha doğrusu ilgili raporu dikkate almazsa sorumluluğu olur mu olmaz mı? Bu hususların açıkça düzenlenmesi, icabında bu raporun pay sahiplerine de iletilmesi ve pay sahiplerinin belli girişimlerde bulunması faydalı olacaktır. Alman hukukunda da benim okuduklarım kadarıyla bu erken uyarı sistemi oldukça detaylı düzenlenmese de belki uygulamasında her benzo şey yapacaktır, değinecektir eğer konu oraya gelirse. Önemli bir görev verilmiş şirket yöneticilerine. Bunları takip edebilmesi için işte 24 aylık süre içinde bir borç ödemede sıkıntı yaşanır mı yaşanmaz mı konusunda takip edebilmesi için önemli bir yükümlülük öngörülmüş. Benzer yükümlülüğün Türk hukukuna da getirilmesi gerekir ve fakat bunu yapacak kişilerin de belli bir niteliğe sahip olması hiç şüphesiz bunun doğru bir şekilde uygulanması için gerekir. Arzu ederseniz bu şekilde yanıtlayabilirim.
Çok teşekkürler. Çok teşekkürler Anıl Bey. Georg, I don't know whether you could follow Anıl's pace. Okay, so good. Because his final comments was about the responsibility of the boards in the corporates. And one of our attendees, who I know as one of the most experienced the experts in our country, who asked more or less the same question. And as I'm just repeating what he has written, Germany and some German-speaking countries used to have the two-tier corporate boards. One of them supervisory board and the other is management board. And these board members used to have personal liability in case of insolvency cases. He's asking that whether this structure is still valid and how does it affect the motivation of the boards?
Well, that's a very good question. So this is still in force. So we have to a little bit go more in detail how a StaRUG proceeding and insolvency proceeding, what are the conditions to step into it. So the liability for the managing board and for the supervisory board is grounded in the fact that a company which has to file for insolvency, not for a StaRUG proceeding, has to file for insolvency, and they don't do it, then the supervisory board and the managing board are responsible for any liability that occurs that the company filed very late too late for insolvency. So this is always still valid, but it's only in relation for insolvency proceedings where you have to step into these proceedings. In a StaRUG proceeding, the company is not allowed to be illiquid or over-indebted, which are the mandatory rules to step into insolvency proceedings, but you need to be imminent insolvent. That means, according to the German definition, when it's quite clear that you will be within the next 24 months that you will be illiquid, then you are imminent insolvent and you have the right, but not the duty, to step into an insolvency proceeding. If you are over-indebted, that means you have not enough sufficient liquidity within the next 12 months, or you are not able at this moment to pay all your creditors, you have the obligation to step into insolvency proceedings. But you are not allowed to step into a StaRUG proceedings. So the StaRUG proceedings are before any of the insolvency obligations are due. And therefore, we don't have a liability of the managing board or the supervisory board if they don't step into this StaRUG proceedings. But this liability will occur, or will be clear, when the company does not go into an insolvency process, although they have the obligation to do so. Hopefully it was not too complicated.
Thank you very much, Georg. Michael, as we speak many rounds on the technicality of the legal background, I'd like to a bit go to the practicality and what is being faced on the ground in the Netherlands. And you in your previous round, you shared some experience that you have in one of the cases. But do you have any particular case that could be a good example of implementation of the new regime in a new scheme that you can share with kind of, let's say, lesson learned and what sort of, and on top of that, together with that, I also would like you to go through what could be the, let's say, the most important obstacles ahead of more efficient restructurings under the existing Dutch regime.
Well, I think there are some general observations and lessons learned, I think. So as I already mentioned, I think that what you can do under the Dutch scheme is actually quite intrusive. You actually amend and take away rights of creditors and shareholders. So that's quite a big hammer to wield. But it does mean that there are certain safeguards around the process. And as I said, it is quite flexible, but in terms of what you need to provide to creditors in terms of information and some of the formal steps we have in the process, which you need to take sort of to safeguard the position of the creditors, the courts are being quite strict about that. So that is, I think that is one of the lessons we have actually learned. You need to provide adequate information. You need to make sure that you have stuff well prepared before you take it to court, before you take it into the voting of the creditors, which in itself, as I said, it can mean that you need to do a bit of paperwork, but sort of if you look at it from the greater scheme of things, I think that's understandable given the fact that actually the scheme allows you to, to significantly amend rights of creditors, even the rights of dissenting creditors. So that is, I think, one of the important lessons learned. I think also an important lesson we have learned, and that more or less relates to what Georg was talking about. We don't have strict early warning signals as in Germany, where the board of directors mandatorily has to file for insolvency in case of certain events. We don't have that in the Netherlands. There are liability grounds for directors if they continue to trade too long. So there is sort of an implicit requirement for them to file for insolvency or at least to actively pursue restructuring measures. And what we have seen in some cases, actually the idea is for the Dutch scheme to save companies which are viable. So although there is no formal requirement, you see that the courts actually, they require that the company is able to continue to pay its debts throughout the process of negotiating and coming to the implementation of the scheme. So that is one of the things they actually look at, so whether the company still is viable. So if you're too late and you just want to file and see, well, maybe I can get a moratorium from the court and I'll see what happens afterwards, that will not work. They will actually look at the position of the company and rule against, for example, a moratorium if it is evident that the company will not even be able to pay its debts. And I think that is also one of the things which always was a point of concern and therefore still is, whether companies will actually turn to advisors or at least take action in a timely fashion. So that is also one of the concerns regarding your last question, Oran. And I think I think those are the two more important lessons from what we've seen in case law so far. And I think the biggest scheme implementation we've seen so far was for a chain of gyms, of fitness clubs throughout the Netherlands. And obviously they were hit quite hard by all the COVID measures. They had the lockdown, they needed to close, so they had financial difficulties in 2020, where the shareholder and the financiers actually put up additional cash for them to weather the storm, to be able to continue until the businesses could reopen again. And what actually apparently what you could see from financials of these companies is that after the reopening, after the lockdowns, that you could see a very strong increase of their turnover and their revenue. So the business itself was quite valuable. It was very clear that they were being hit very hard by the lockdown measures. So 2020 was saved. The company had sufficient funding from the sponsor, shareholder, and the financiers, and they ran into similar issues in 2021, early 2021, when a new lockdown was issued by the Dutch government. So again, they turned to the financiers, and again, the shareholder was willing to put in additional funding. but the financier was also required to, I'm not even sure whether they were requested to put in additional funding, but they needed to take there was a covenant holiday was requested, so the covenant testing should be postponed, obviously because the covenants were sort of set for a normal course of trading, and that would not be they would not be able to make that in the year, and a interest roll-up was requested. The financiers didn't accept that. What we see, sort of, this is all a bit. The rulings are anonymized in when they're published, so it's all a bit vague at some points. But we believe that at the time when all of this was playing out, there were a lot of funds were involved, no longer the original Dutch banks. And the funds were actually taking quite an aggressive stance. They claimed payments, they accelerated the loan, and at some point they even wanted to take enforcement action over the share security. And it is more or less apparent that they were pursuing a loan-to-own strategy. So the company filed for a moratorium under the Dutch scheme, sort of to fend off these enforcement actions from the lenders. And there was a lot of negotiation, there was a lot of litigation going on all aspects of the Dutch scheme. And what eventually happened is that sort of the proposal which was made to the lenders in the consensual restructuring negotiations in 2021 eventually was the scheme which was proposed. And as I said, so you had this class of secured creditors, you had super senior and senior creditors. So as background, one step back, in the scheme is proposed to creditors, to shareholders, whoever are impacted by the scheme. And then these parties are divided into classes based on similarity of their rights. So the similarity of their rights in a bankruptcy, so if they're a secured creditor or preferred creditor, that could be one of the points for dividing them into a similar class, or whether the rights they are being attributed under the scheme are similar, they should also be in a class for that. So in this case, you had the super senior, you had the senior class, and you had the tax authorities in a class. And the tax authorities were being offered actually what was in line with the common policy for restructuring of COVID-related debt. We had a postponement of tax payments, and there was a regulation how that should be repaid, and which was quite a relaxed regulation. So that was actually made as a proposal to the tax authorities, which was one class. And the same proposition as which was made earlier in the year was made as part of the scheme to the senior and super senior class. And what happened then, and that's also something to note, we have the concept of cram down in the Dutch scheme, which means that if one of the classes of creditors or shareholders who is impacted by the scheme, if they are in the money class, that means that if in a bankruptcy they would be eligible for a distribution from the bankruptcy, so then they are in the money class. If one of these in the money classes votes in favor of the scheme, you can actually cram down, so you can actually force the scheme on dissenting creditors and on dissenting classes of creditors. So what happened here is that actually the Dutch tax authorities were made a proposal which was completely in line with what they would have implemented otherwise. So they gladly accepted. They were in the money class, but they only held, I think, 6% of the debt, the total debt amount of the companies. And the senior securities, which held the massive amount of the debt, they voted against, but they were actually crammed down through this system because of the positive vote, because the vote in favor of the Dutch tax authorities. And obviously they objected against that by the court, but it was actually upheld by the court. So based on this one vote in favor of this preferred creditor, it was shown that the company was actually able, and it was not the company, but at some point a restructuring expert was appointed. So the restructuring expert made the proposal, and the courts accepted it based on this vote from this preferred creditor. And that actually led to what I was explaining earlier, that the lenders, the funds, were actually forced to accept, or at least the amendment of the credit agreement was actually an attachment to the scheme proposal. So there was an amended credit agreement, which was the proposal under the scheme, and that was actually forced upon the senior creditors. So they are forced to continue their financing for a couple of years. There is a PIK interest, there is a covenant holiday, covenant resets. Some of the covenants have been added, and they were just simply forced to accept it.
Well, quite an important experience that the old system has. It seems that's like a big test for the new scheme.
Absolutely.
So as we are coming to the end of our planned time for the session, and of course there are much to discuss and much to share, but try to be aligned with the planned times. In the last round, I will ask to each participant, each panelist, that for whatever you want to tell you, or is there any important aspect that we are missing from the Dutch or the German system, or any final closing remarks from your side to the audience? And I will give floor to each of you. Georg, would you please start?
Well, yes. My concern is that not only in Europe, but in Turkey and in the US and in the UK as well, we need similar systems. So sometimes when we have group insolvencies or group restructurings, it's quite difficult to get it done in the different jurisdictions. And if you have to file for insolvency, one of the jurisdictions, you have always a certain impact on the whatever other companies. So I think we made with this StaRUG, this EU directive, and as I heard, as you discussed it in Turkey as well, a big step towards united restructuring regime. But I think that's quite necessary because we all have these structures over several jurisdictions, and I think that's always the thing when we are working a lot in cross-border work. And then we look how difficult it is to implement something in Austria, although Austria is German speaking, but it's totally different. They have this reorganization regime. It's as well something from this EU directive, but it's quite different. And we saw that this does not fit together in one bigger cross-border restructuring. So we had to decide whether we step into an insolvency proceeding in one jurisdiction and StaRUG one in the other one. So what I want to say, that is the main concern, and hopefully, so I'm doing now this work for more than 20 years or almost 30 years. And there are big steps towards one united regime, but it's not fast enough because we have this globalization. We need much more flexibility, and sometimes I think all the jurisdictions are not fast enough to go with the developments of modern times.
Thank you very much, Georg. Michael, you are on mute, sorry.
Sorry about that. Now, there are 3 points I just quickly wanted to touch upon. I realized we haven't yet discussed. I wanted to mention that the Dutch scheme proceedings is a debtor in possession proceedings. So management boards continues to manage the company and manage its affairs, even if a restructuring expert is appointed. His sole task is to prepare and to propose the scheme, but he doesn't run the company. So I think that is an important aspect and a big benefit of the proceedings. Second point I wanted to make is referring back to what Georg said about the experience of the judges. What is done in the Netherlands, we have 11 of these the separate the 11 courts in the Netherlands with their own jurisdictional area, and they have insolvency courts within the district courts. And what all of these courts have done, they have nominated one of their judges to become a judge for Dutch scheme cases. And all requests, all applications are ruled upon by 3 of these judges. So if I file an application here in Rotterdam, the allocated judge from Rotterdam will review it together with 2 specialized judges from other jurisdictional areas here in the Netherlands. They were trained before the Dutch scheme was actually implemented, so they were very well versed in the scheme and what it intended. And you see now that they also gain obviously a lot of experience because they see all of these cases and they rule on all of these cases. So I think that is actually quite a good approach, I think, to ensure that they are very well trained and become experienced as we do in how things develop. And I think even because of the quite large amounts of applications, they have now each jurisdictional area has nominated the second judge for this pool. And I think the third point, I agree with Georg that there is still a lot to be done in terms of alignment of insolvency proceedings. What we have seen in the Dutch scheme is that the Dutch legislator has been quite lenient in terms of jurisdiction of the Dutch courts. So the Dutch scheme does provide for a lot of possibilities to have foreign entities, to include foreign entities, to include group entities in Dutch scheme proceedings. But still, that would mean that you would have to take foreign entities into the Netherlands to some extent, or at least have them appear before a Dutch court. We also I'm not sure how that works for StaRUG, but we have a disclosed and a public possibility for the Dutch scheme, and the public possibility for the scheme would be is now included in Annex A of the insolvency regulation. So that would be recognized in all of the EU member states. But yeah, and that is one thing we are looking forward to. Keen to see that we haven't yet had any international experiences with the Dutch scheme. So we're interested to see how that works out.
Well, as I heard many times that the Dutch scheme could be a possible alternative among the possible alternatives of UK system after the Brexit, but looking forward to see some examples in the Netherlands in the future as a second alternative to the UK system, I would say. So, Anıl Bey, aslında bu round özellikle sizi sonda bıraktım. Sizden de benzer bir şekilde bir son değerlendirmelerinizi ve bütün bu konuştuklarım üzerinde sizin özellikle bunun da altını çizmemiz gerektiği dediğiniz bir husus varsa sizden de onları dinleyelim. Ondan sonra da artık yavaş yavaş panelimizi kapatacağız. Buyurun Anıl Bey.
Teşekkür ederim Orhan Bey tekrar. Tabii önceki sözlerimi tekrarlıyorum. Tekrar söylemek gerekirse artık dünyadaki genel yaklaşımın borçların tasfiyesinden ziyade borçlu şirketlerin güçlendirilmesi olduğunu görüyoruz ki bu geleneksel iflas yaklaşımından da tabii farklı. Tabii burada hemen tüm alacakları eşit davranma kuralı bildiğimiz gibi iflasta, hatta bu dönem en çok uygulaması olan konkordato da gerekli. Ama işin niteliği gereği bazı alacaklıların yapılandırılması borçlu için, borçlu işletme için çok daha önem kazanabilir. Hep verilen örnektir, bizim de verdiğimiz örnektir. Borçlunun ham madde tedarik ettiği alacaklısı ile borçlunun şirketinin güvenliğini sağlayan alacaklı borçlu bakımından önemi birbirinden farklıdır. Dolayısıyla bunlara biraz daha açık olmamız gerekir. Yine sürecin inisiyatifinin borçluda olması, sınırlı durumlarda buna mahkemece müdahale edilmesi gerekir. İşte Alman hukukunda böyle bir durum esasen söz konusu. Tabii bugün konuşulmadı belki süre sınırı sebebiyle ama tabii Almanya'da da mahkeme gerekli durumlarda proje plana bakımından bir denetçi atayabiliyor. Yeniden yapılandırma görevlisi atayabiliyor ve o projenin hazırlanmasında borçluya yardımcı oluyor. Gerektiğinde müzakereleri yönetmekte. Bizim de açıkçası bu düzenlemeleri hukukumuz bakımından düşünmemiz gerekir. Başlangıçta Önder Bey'in söylediği gibi oldukça dağınık bizdeki düzenlemeler, bazıları yeterli değil. Bu bakımdan böyle bir panel hiç şüphesiz bu konuda bir farkındalığın da yaratılmasına hizmet etmiş olduğunu ben kendi adıma düşünüyorum ve bu paneli düzenleyen sizlere, başta Önder Bey ve Orhan Bey size olmak üzere tüm TMA ailesi ve FOYDER ailesine teşekkür ediyorum bizlere böyle bir fırsat verdiğiniz için.
Çok teşekkürler Anıl Bey. Genelde böyle dakik olmak her zaman önemsediğim bir şeydir ama bu sefer herhalde tam tamına 90'dan vuracağız tabiri yerindeyse. Toplantı için öngördüğümüz 1 saat 30 dakikalık sürenin de sonuna gelirken de aslında bugün de panelin kapatmaya da yakınız. Ben bu vesileyle aslında bugünkü toplantıdaki tüm katılımcılara, başta panelistlerimiz ama sonrasında bize dinleyen, soru soran, bizleri takip eden bütün katılımcılara çok teşekkür ediyorum. Anıl Bey'in söylediklerine o anlamda ilave edeceğim bir şey yok. Bu tarz farklı ülke deneyimleri, özellikle bu alanda iş yapan finansal danışmanlar, avukatlar, bankacılar, şirket yöneticileri ne kadar çok başka ülkedeki deneyimleri, başka ülkedeki öğrenilmiş dersleri daha iyi kavrarsak Türkiye'deki rejimin, Türkiye'deki mevzuatın geliştirilmesine hep beraber düzenleyici kurumlarla birlikte, hep birlikte bu konunun geliştirilmesine teşekkür ederiz. Son iki yabancı konuğumuza da teşekkür edeceğim. Dear Michael and Georg, very fruitful meeting, and I very much, let's say, learned from Even you didn't speak about the more deep details, but still it was so effective for all the audiences, and I really would like to thank you to both to joining us and helping us to understand the recent developments in the insolvency regulation in both countries. Thank you very much to both of you. Bu vesileyle tekrar bütün katılımcılara katılımları için çok teşekkür ediyorum ve panelimizi de sonlandırıyoruz. Herkese güzel bir gün diliyorum. İyi günler. Have a good day.
Thank you.
Teşekkür ederim.